Get ready for the dictation on the count of 3, 2, 1, start. As observed by the Supreme Court in Associate Builders versus Delhi Development Authority reported in 2015 3 SCC 49, the 1996 Act was enacted to provide for an arbitral procedure which is fair, efficient, and capable of meeting the needs of arbitration, to provide that the arbitral tribunal gives reasons for an arbitral award, to ensure that the arbitral tribunal remains within the limits of its jurisdiction, and to minimize the supervisory role of courts. Section 5 of the 1996 Act provides that, notwithstanding anything contained in any other law for the time being enforced in matters governed by Part 1, no judicial authority is to intervene except where so provided in the said part. Section 34, read in conjunction with Section 5, makes it clear that an arbitral award that is governed by Part 1 of the 1996 Act can only be set aside on grounds mentioned in Section 34, 2 and 3 and not otherwise. None of the grounds contained in subsection 2A of Section 34 permit the court to adjudicate the merits of the decision rendered by an arbitral tribunal. The merits of an award might only be looked into under certain specified circumstances, when an award is found to be in conflict with the public policy of India as held by the Supreme Court in Associate Builders Supra. In Renusagar Power Company Limited versus General Electric Company, reported in 1994 Sub 1 SCC 644, the Supreme Court held that the expression public policy in the context of a foreign award would have to be construed to mean an award contrary to the fundamental policy of the Indian law, or the interest of India, or justice or morality. Such an award would have to be set aside as contrary to the public policy of India. In ONGC Limited versus SAW Pipes Limited, reported in 2003 5 SCC 705, the Supreme Court held the phrase public policy of India is not defined under the Act. Hence, the said term is required to be given meaning in context and also considering the purpose of the section and scheme of the Act. It has been repeatedly stated by various authorities that the expression public policy does not admit of precise definition and may vary from generation to generation and from time to time. Hence, the concept of public policy is considered to be vague, susceptible to narrow or wider meaning depending upon the context in which it is used. Lacking precedent, the court has to give its meaning in the light and principles underlying the Arbitration Act, Contract Act, and constitutional provisions. An award would be set aside if it was contrary to the fundamental policy of Indian law, B, the interest of India, or C, justice or morality, or D, if it was patently illegal. In ONGC Limited versus SAW Pipes Limited Supra, the Supreme Court made it clear that it was open to the court to interfere with an award on the ground that it was patently illegal and therefore opposed to the public policy of India. An award might be set aside as patently illegal provided the illegality goes to the root of the award. If the illegality is of a trivial nature, it cannot be said that the award is against public policy. This proposition was reaffirmed by the Supreme Court in Hindustan Zinc Limited versus Friends Coal Carbonization, reported in 2006 for SCC 445 in ONGC versus Saw Pipes Limited Supra, the Supreme Court held that an award could also be set aside if it was so unfair and unreasonable that it shocked the conscience of the court